Let's go on the record. This is cause number 2021 CR 4395, the state of Texas versus Ray Garcia. Attorneys, please make your announcements for the record.
Yes, Your Honor. Luis Echeverria for the state of Texas.
John Economidi for the defendant, whose correct name is Gracia, Gracia.
Ah, you're right. It's Ray Alexander Gracia, Gracia. Thank you, Mr. Economidi.
Yes, ma'am.
Go ahead and tell me your full name for the record, Mr. Gracia.
Ray Alexander Gracia, Your Honor.
Okay. We're here for the results of all of the evaluations that I've ordered. I did order a TAP evaluation and a DDRF evaluation. And this is a recommendation of deferred adjudication. Because this is a repeater, so it's a second degree felony. Let me go ahead and take his plea on the repeater count, Mr. Economidi.
I thought we did that back in like September, but
I normally,
the plea would be true to the repeater.
okay, so let me read it to him. Mr. Gracia, are you the same Ray Alexander Gracia that in cause number 2011 CR 7412 was found guilty of the felony offense of assault family second offense? Is that true or
Yeah.
not true?
True, Your Honor.
Okay, thank you. I will enter a plea of true, and I do find that it is true. Now, Mr. Economidi, do you want to talk to me about the results of the DDRF evaluation?
The DDRF confirms that he does have a dual diagnosis, bipolarism and anxiety. Just to refresh your memory, going way back when he was entering his plea originally, he came to court and he had just gotten out of the hospital with cardiac myopathy. So he had some multiple medical problems beyond his mental problems. They confirm this, they recommend different DDRF. I think it's appropriate for him to be under medical control, and DDRF would be doing that. It's still up to the client to overcome his past drug problems, in addition to getting help for his medical problems.
Generally, what is the status of his health right now? Because for a residential facility, he probably would not qualify if he has some ongoing medical issues.
Speak up.
Oh, the cardiologist said that I don't have cardiomyopathy. That's not my diagnosis. I'm seeing a cardiologist, but he says I'm fine, miss.
Do you take medicine on the daily basis?
Just for my mental health, I take like 5 or 6 meds. That's it. I'm not taking for my cardiomyopathy no more. That was just a problem that just happened for one night. That was it.
Okay, and what about, who are you seeing for your mental health?
Center for Healthcare Services. I see them. I saw them every week, but now I see them once every 2 weeks or something like that.
Okay, and you're currently taking all of your medications?
Yes, ma'am.
Are you stable with your medications at this time?
Yeah.
Okay.
Yeah, I am.
But your physicians indicate that you still need to take your medications to maintain your level of mental competency.
Yes, ma'am. Yes, sir.
All right, what I'm gonna do, Mr. Economidi, is I'll hold the residential component in abeyance, and I state, I don't know if you wanted to add to any of that, but it is a recommendation of deferred, but you're welcome to add to that.
Your Honor, well, the state, just briefly, Judge, the state does seek DDRF for him as well, and that is based on the mental health evaluations. Again, it's been stated by his attorney of record to include bipolar and anxiety, as well as PTSD. As the court well knows from the mental health evaluation, he was approved for that, Judge. He does meet criteria for the target population. And he does express other concerns for the state to include things like paranoia and anxiety, or appearing to be overly anxious at times. So with that, Judge, with that, the mental health evaluation, the approval for DDRF, the state's position is that he should go to DDRF at this time.
All right, I'm gonna do dual diagnosis outpatient because we need to save those beds for someone who's not as stable as Mr. Gracia appears to be. This is what it means for you, sir. You're gonna continue with the Center for Healthcare Services, and you're gonna be supervised by a unit that's gonna make sure you're taking your medicine. The minute you decide not to take your medicine, this DDRF, the residential part of it, is still in effect. It's just held in abeyance. So you don't need to come back to court. If your probation officer tells me that you are not taking your medications, or you're missing your appointments, or you're just not complying, then DDRF is gonna be the place where you need to go. And that's residential, and that's much longer. There's a wait to get in there, and the treatment plan itself is several months. So
Yes, ma'am.
I would like to try outpatient first. So dual diagnosis, outpatient treatment. I'm going to hold DDRF in abeyance, the residential part. As a condition of your probation, so let me just go ahead and proceed. I do find the evidence is sufficient to substantiate your guilt. I will make no other findings. This is a recommendation of deferred for a period of 6 years, $1,000 fine. The state is going to dismiss 2021 CR 4396 and 4397. 200 hours of community service. I'm going to hold those in abeyance so that you can comply with your mental health treatment. You're going to forfeit the weapon in this case. As a condition of your deferred, there is no weapons allowed, no possession of weapons. And I do want you to take the moral recognition therapy course. We're going to do dual diagnosis outpatient, mixed supervision. Until he gets into the mixed supervision program, I would like him to see a high-risk officer to make sure that his medication is in compliance. You will also, as a condition of your probation, continue with the Center for Healthcare Services and all of its treatment recommendations, because your probation officer will ask you to show proof that you're going to your appointments.
Yes, ma'am.
This is a plea bargain case. I did follow the plea bargain agreement. You do not have a right to appeal. Do you understand?
Yes, Your Honor.
Have a seat in the front row. My probation officer is going to give you some documents to go over. Yes, sir. Thank you, Mr. Economy. Mr. Economy, can I ask you to hang around just for a quick minute in case I don't have his. Okay. Yes, sir.
Ashley, we're ready on a plea on Raymond Garth.
Okay, Judge will take them as she got the paperwork. Warren, I'm showing Berlanga needs to sign.
I'm sorry, did you say my name, Ashley?
No, Warren Wolf.
Warren, oh, sorry.
I guess put me in a breakout room with him and I'll make sure I'll help him get this done. Thank you.
Pretty Judge Joseph Gutierrez is the last
Mhm.
name. Mr. Page. I checked if he was there in jail, but I heard he got released that same day.
Okay, no problem. Jose Garcia, are you online? Yeah, I see.
Can you hear me?
Yes, I'm going to reset your compliance hearing for a couple of weeks so that you can get over the COVID symptoms.
Okay.
So I want to see you back in person February 28th,
Yes, ma'am.
and it's in person.
Yes,
Thank
ma'am.
you.
Yes, ma'am. February 28th.
Thank you.
Thank you.
For those of you who have a plea ready, I'm going to start pulling up all the paperwork. So give me just a minute.
Can I leave the meeting?
You're excused, yes.
Well, thank you. February 28th.
Okay, these are the pleas. This is the order I have paperwork. Number 1 is Ricky King. Number 2 is Timothy Berlanga. 3 is Rachel Ortiz, and 4 is Henry Rodriguez. Are all those people sworn in and ready to go?
Yes, Judge.
All right.
Your Honor, before the pleas, may I address the court briefly on an issue?
Yes.
We're representing Jeffrey Olivari, and I talked to Gretchen, and this is an MTR that has a new number 1 of aggravated assault. And the alleged victim in this case also is pending an aggravated assault with the DA's office. I have asked Gretchen for the file for the victim's pending aggravated assault as Brady. And what she's asked is that the court order her to turn it over so that they can get it, the discovery transferred to my name so that I can access that, as it can be used for impeachment or to establish a self-defense claim on behalf of my client. I can do a written motion and order. And if that is the case, and if Your Honor grants it, then we'll be able to, I guess, get that information or evidence that we might need in order to defend Mr. Olivari in his case.
So just to be clear, the aggravated assault, so there is a complainant, there's an indictment with a complainant accusing Olivari of a new aggravated assault.
Right.
That complainant has an aggravated assault himself for the
Yes.
same transaction?
I believe it's a different one.
No, it's a different transaction. So this is one that was in your court and got transferred to another
Yes.
court.
Right.
Yeah. It was already not the same transaction.
And so, Your Honor, if we establish a self-defense claim, part of our ability to establish self-defense is to show violent character on behalf of the complaining witness. And as well as if the complaining witness testifies, we could possibly use information that's found within his file to impeach that witness. And so that's why we're making our Brady claim. And that's why we're asking for that file. And the prosecution would just ask you for an order, ordering them to turn that file over to me for the purposes of Brady. Possible impeachment, possible establishing of a self-defense claim by the violent character of the victim. Under Rule 405 or 404A.
So you could only use that subject to cross-examination if he gets up there and says, I'm just thinking ahead, because if it's not the same transaction, it seems a little remote to me. How do you connect the two?
So Rule 404 in the Texas Rules of Evidence allows me to get into a pertinent character trait of the victim, which would be the character for violence. If my client is claiming self-defense because the victim acted in a certain way, and in this other case, which I don't know about, he acted in that same way with a different person, then it goes to show that the victim is the first aggressor to establish the self-defense claim. At first.
So
Second,
why do you
we could
need-
also use
Why do you need the full discovery? Why can't that just be satisfied with the police report of that led to the indictment in his aggravated assault?
Well, I guess because, for instance, let's say there's a police report, but then there's also a witness statement that says something different that wasn't found in the police report, but I only got the police report because I was limited to that. Then potential Brady or exculpatory or impeaching or mitigating evidence could be found in a witness statement that I didn't receive because I was limited in what I could receive. So I think that under 3914 under Brady, I think that by just giving the police report, and in my experience at the DA's office for many years, police reports often leave out important information that is found in other areas of the file. I think that what could happen is if I'm not granted access to the entire file, then I could potentially be denied Brady that nobody even knows about until we get there. And then we go, oh yeah, there was this other thing too on a post-conviction writ, or something like that. So I guess my issue is I don't know what's contained therein. So I don't know what is or what is not. So I have to ask for everything. And I can do that under a protective order from the court, that it's only to be for my use or my investigators' use to investigate the client's self-defense. The client will not get any copies of it, just like 3914. Yeah. But that information that the person, the DA's office is prosecuting the victim in our case violent conduct, I think is necessary and important for me to understand what that conduct was and what the circumstances were.
Okay, well, at this point, why don't you file your motion? Tell me exactly what you're asking the state to tender to you, and then also file a protective order. Because I guess my other question is, why can't the DA just bring down the file down here and you review it, and then I can rule on the motion depending on what you see there? What if, I just have a hard time on an unrelated matter giving you the discovery since you're not his attorney of record. But I mean, you can certainly allow it to inspect it, file your motion, inspect it, and if there's something that you want me to rule on, then we'll urge your motion, we'll have a hearing on it.
Yeah, I don't have any issue as far as that's concerned. I think that the DA's office felt like, I think the DA's, and I don't want to speak for Gretchen, but I think that it's just easier for everybody involved if it's under a protective order, because then they can just open the discovery to me based upon your order. By doing this and going down and doing all that, it's just, it'll take longer, I think. And I understand that time is not always the court's main consideration, but my client is in jail and he's on an MTR. And so instead of like a couple week reset, we might need, longer than that, because for me to get down there, inspect it, and then go back to the court and ask for specific items that are coming out of that file.
Well, I think it's not too much to ask the state to have one of their investigators download everything or print it for you and make it available to you, and then I can more appropriately rule on your motion. Maybe you don't have to come in person to inspect it. Maybe Falon can just print it or put it on a USB for you.
I understand.
But for the state to open up the discovery the way you're suggesting creates some problems because you're not his attorney of record. So
it is true. I would say that for us, just so that the court knows, any item in that file that deals with the complainant, in our case's potential commission of a violent crime, I'm going to ask the court to give over, which theoretically, unless that there's just a bunch of irrelevant things in their file, that's going to be their entire file. It's going to be all the body cam, anytime anybody's discussing this man, any witness statement, anything about how this offense occurred or where it occurred or when it occurred. That would be, I guess, accepting, even any evidence of the victim's previous violent conduct would be almost encompassing the entire file. But if that's what the court wants me to do, I will definitely come down there and review the file.
all right, well, how much time do you need to tender it over to him, state?
Judge, once he has the order, it depends on what you're ordering. So if he's just going to be allowed access to the e-discovery, then, once you do the order, I think our IT people can get that done very quickly. If you are ordering that he review the file, it got transferred to another court, so we'll have to locate it and then arrange a day and time where he's going to be present so that he can review everything.
I don't see how I don't think opening up the e-discovery is the way to do it. I think you're going to have to go through the physical file, because to assume that everything is on e-discovery is just not a good assumption. I don't know how old the case is. I don't know if anything has been updated. I would just do both. Get the electronic discovery and inspect the file. But I need to see your motion. I need to see your motion and your order.
Your Honor,
what I don't want is this complainant, then his attorney coming back and saying, why would you do that? Why would you allow him to see her client's file? So
sure.
I hear your argument. Just file your motion and let me take a look at it.
I understand. We'll do that. We'll have a motion filed by the end of the day.
But am I understanding you're going to set this for a contested?
Well, it's not, I guess, how will I know whether or not to set it for a contested unless I know what all the evidence is? I have to be able to review that with my client before I can say, we need to not contest this, or we do have a good basis to contest it based upon the violent history of the victim. If it is, like, I don't even know what the case is. and I don't know that Gretchen necessarily knows like all the facts of it. And that's why it's just, for us, it's just let me see it so that I can make a decision, and then I can negotiate with Gretchen and let her know whether or not we're going to contest it or whether or not we're going to plea.
So I won't set it for a contested. I'll give you a regular reset until March the 14th. And then that day, I would like an answer, please. And I will definitely rule on whatever you file right away.
Okay, thank you, Judge.
Okay, thank you.
And we've excused.
Yes, thank you.
Thank you.
Yeah. Timothy Berlanga, what case are we going to proceed on?
Judge, we are proceeding on the evading and the 2021 PCS less than a gram.
Rachel Ortiz is taking a plea on both.
Yes.
Pero en my case, posiblemente todas las copias de un permiso se me quedan en el papel y yo no voy a hacer. Dice, entonces tengo que la pega hacer un abogado. Para el de la de esa aquí directo. Él es un tacho. Él es el 15. Esta gente aquí de New York, dicen que yo tengo.
Thank you, Eddie.
I don't want to do it too hot.
Sorry. Thank you.
No, no, well, I'm good for 2.5 weeks.
Yeah, it's a little hot.
Well, I don't know if the speculative that we have.
Mr. Longacre, I have not seen him.
You know, I forgot to get an announcement from Mr. Economidi on Lane Wooten.
He's keeping it on the trial track, Judge. It's reset to 4-6.
Thank you.
I'm confused. So Joseph Gutierrez had a parole. He was sentenced on parole. So how did he get out?
You're 10 steps ahead of me.
I was asking Ashley.
Hey, Gretch, according to the booking, his warrant was withdrawn from parole.
Oh, that's right. That's right. I remember that part. Okay, so I do have paperwork on Pastrano, and I see some paperwork on Alvaran Gutierrez. Alvaran Barrientos. So, what's the plea? What happened with Eric DeWalt's MTR?
It got reset to 411. He has a new ag rob that Eric needs to get discovery on, and I need to get up to speed on. We need to talk to the victim on that case.
What about Rufus Brown? Is that a trial case?
Yes, 4-6.
And then Angelina Flores, she a
Plea.
plea, right? Okay. I saw some paperwork for her, so she would be number 6. And then Sharon Thorne's Donald Hastings. I think she just got appointed to that.
She did. I don't know what happened with that yet.
Reset to 411.
And Joseph Gutierrez,
He's bond forfeiture. He's not here.
and Perez Martinez.
4-6.
Okay, so I have 6 pleas ready to go. I can do them all. Or I can give people the option to come back at 1:30. So if you want to do your plea, hang tight, I'll get to you.
In your honor, just
It's like I
very
have
quick,
paperwork.
very briefly, Judge, there should be maybe a 7th one. I don't know if you included Raymond Garza, Mr. Garcia's client. Raymond Garza also is a plea judge.
Oh, yes.
It's a plea as well. Paperwork's been done, Judge.
I thought she had said she had done it. Okay.
Paperwork's been done.
Sorry, I wasn't paying attention.
So, so I did get Pastrano first, then Alvaran Barrientos. Luis, yours is Garza. Yeah, that's the last one I got. I got that one at 11:27. So
You
that'll
should
be
have
number
gotten
7.
King. You should have gotten King first. That's Lauren
Yeah.
Lupton.
That's the one I said was first. Yeah, it's King, Berlanga, Ortiz, Rodriguez, Pastrano, Flores, and then Alvaran Barrientos, and then Garza. I got the paperwork in that order. So if you're an attorney and you're on and you're at the bottom of the list, you can either wait or you can come back at 1:30. But I do intend to just keep going. I have them all now.
Judge, you don't have Posada, Rolando Posada? This is Amir.
Yeah, I called his name. He's like number 2.
Okay, I'm sorry. I didn't hear it. Sorry, Judge. Sorry.
Your Honor, may I interject for a second on Joseph Gutierrez?
Yes.
Kenton Longacre here. I didn't have the best, apparently, what is the best contact number for my guy until earlier this morning. I've left 2 messages there. I'm asking if you can hold off a few days before forfeiting his bond. There was a lot.
I have a 1:30 docket. Can he come at 1:30?
I don't know. I can't reach him yet.
I'll hold off until the end of the day, but he does need to appear today.
Okay, I will stay on it. Thank you, Judge. May I be excused for now?
Yes, sir. Thank you.
Thank you.
Let's go on the record on Ricky King. Mr. King, go ahead and unmute yourself.
Hi, Judge.
Hi, Lauren. All right. This is cause number 2022 CR 1232W, the state of Texas versus Ricky King. Attorneys, please make your announcements for the record.
Gretchen Plater for the state.
Lauren Lupton for Mr. King.
All right, Mr. King, I have on the screen the information that was filed in your case. It alleges the offense of evading arrest or detention. Looks like it's enhanced, so it's on foot.
Yes, ma'am.
Before we go to the range of punishment, Mr. King. Hang on, where's Mr. King? Go ahead and unmute yourself, sir.
Hello?
Okay, Mr. King, can you hear me?
Yes, yes, I can.
Go ahead and state your full name for the record.
Ricky King,
I can't hear you. Try it again.
Ricky King.
Okay. Mr. King, on the screen, I have a document that I want to go over with you. It is called the waiver of grand jury. In every felony case, you have the right to have your case presented to the grand jury. Are you paying attention, Mr. King?
Yes, this
Okay.
computer is on mute, is on.
I'm having a hard time hearing you, so you're going to have to speak up and stop moving the mic.
Sir, can you unmute this? The judge can.
You're unmuted, Ricky. You're unmuted. So you just need to focus on speaking into the microphone, okay?
Mr. King, I was explaining to you that in every felony case, you have the right to have your case presented to the grand jury. If the grand jury delivers an indictment, then you have 2 days to review the indictment with your attorney. You also have 10 days to prepare for trial. When you sign the document that I have on the screen, what you're telling me is you're going to skip that process. You're going to give up those rights. Is that what you intend to do?
Yes, yes, ma'am.
Is this your electronic signature where it says Ricky King?
Yes, ma'am.
I will sign the waiver of rights, the waiver of indictment and information and make it part of the record. Mr. King, so you are charged by way of information with the offense of evading arrest or detention, and that's evading on foot. So it's enhanced with a prior conviction, prior misdemeanor conviction. And that's a state jail felony. It is punishable by confinement in the Texas Department of Criminal Justice, the institutional division, for any period between 6 months and 2 years confinement in a state jail facility. It also carries a possible fine of up to $10,000. Do you understand the range of punishment that applies to that charge?
Yes, ma'am.
You have the right to a jury trial. You have the right to cross-examine the witnesses against you. You also have the right to remain silent, Mr. King. Those are your constitutional rights, sir. Do you understand those?
Yes, ma'am.
When you sign the waiver of rights, what you're telling me is you're going to give up those constitutional rights. Is that what you intend to do?
Yes, ma'am.
Is this your electronic signature above the words Ricky King, defendant?
Yes, ma'am.
Are you a citizen of the United States?
Yes, ma'am.
If you are not a citizen, I'm still required to tell you that a plea of guilty or no contest to this charge could result in deportation, exclusion from admission to the country, or denial of naturalization under federal law. Mr. King, are you satisfied with the representation of your attorney?
Yes, ma'am.
Ms. Lefton, does your client have a rational and factual understanding of the proceedings against him?
Yes, he does, Your Honor.
Has he been able to assist you in the preparation of any defenses?
Yes, Your Honor.
In your opinion, is he mentally competent to waive his rights and enter into a plea?
Yes, he is.
I will accept the waiver and make it part of the record. Mr. King, on the screen, I have the agreement you made in this case. The agreement calls for 100 days confinement in the Bexar County Jail pursuant to 1244 of the Penal Code. There's no fine and no applications in this case. Is that your understanding of the agreement that you made today?
Yes, ma'am.
Ms. Lefton, is that your understanding?
Yes, Your Honor.
And Ms. Flater, is that your understanding?
Yes, Judge.
Mr. King, what is your plea to the charge of evading arrest or detention, second offense? Is it guilty, not guilty, or no contest?
No contest.
Are you entering a plea of no contest because you have talked about this matter with your attorney and you believe it's in your best interest to do so?
Yes.
Mr. King?
Yes,
Yes?
ma'am. Yes, ma'am.
And are you entering this plea freely and voluntarily?
Yes, ma'am.
Has anyone forced you to enter a plea
No, no, ma'am.
or offered you anything in exchange for your plea?
No, ma'am.
I will accept the plea of no contest. I do find the plea is voluntarily made, and I will ask the state to tender its proof.
State offer States Exhibit 1 and its attachments.
No objections to that, Your Honor.
States 1 is admitted. Ms. Lefton, are you satisfied the state complied with Article 3914 in this case?
Yes, ma'am.
I will sign the discovery acknowledgement and make it part of the record. Okay, give me just a minute.
Ugh. Texting, that's funny. Finishing.
State, there was no other charges for resisting or anything like that.
No.
Okay, let's go back on the record. I do find the evidence is sufficient to substantiate your guilt, Mr. King. I'm going to find you guilty of the offense of evading arrest. Second, that's a state jail felony. I will sentence you to 100 days confinement in the Bexar County Jail pursuant to 1244 of the Penal Code. How many days does he have in, please?
52.
You do get credit for the time you have been in custody on this case, and I do find that the judgment is satisfied. Mr. King, this is a plea bargaining case. You made an agreement and I followed it, so you do not have a right to appeal. Do you understand?
Yes, ma'am.
Okay, thank you. You're excused.
Thank you, Your Honor. May I be excused also?
Yes, ma'am. Thank you for your patience.
Thank you. Have a nice day, everyone.
You too.
Can I ask a question? Can I leave?
Yes, sir. You're excused. Let's go on the record on Timothy Berlanga. Mr. Wolf, you know he has some holds.
What are those, Judge?
Out of county holds. Comal County, I think.
Well, nothing could happen up there until we complete this.
You're right.
And they're sentencing him to, we're agreeing to some prison time. So hopefully they'll defer.
Oh yeah, let me get those case numbers.
I'm not on those cases out of county.
No, but I'll run them concurrent.
Thank you.
So he's taking a plea on 2 cases, right?
That is correct. One is going to be a JSAT, the other is for some additional time.
Okay, I'm going to skip on to the next plea. You're missing one plea packet on 0091. I don't have 0091. I didn't realize he was taking two pleas.
0091's being taken into consideration, Judge.
No, the other one is I have paperwork for 0092, 0091 is going to get dismissed, and then plea paperwork on 10123. So that 10123 plea packet is missing. I apologize. Maybe Gretchen can help you send
Yeah, I'm in the middle of another set of plea paperwork, so as soon as I'm done with that, I'll check on it. My recollection was everything was with you, Judge, but I'll send a reminder.
Yeah,
I could
I have to
recall
pull it up.
signing that.
I have everything else, the discovery acknowledgement and everything else to 10123, but not the plea packet itself. Clerks, did you receive that plea packet? So let me do the next one. Let me do Rachel Ortiz while you guys locate that one. Let's go on the record on Rachel Ortiz, please. Who's the attorney?
John Winter.
Is John on? Have we heard from John? Is he coming back?
I'll ask him if he wants to get on or come back at 1:30.
All right, then I'll go on to Posada.
Judge, this is Amir on Posada. His phone says Cricket Splendor, Judge, FYI.
Okay, go ahead and unmute yourself, sir.
Okay.
Judge was right, Warren. I just sent a reminder. You need to go to the breakout room with him. It should be at the jail still.
Okay, send me there, Ashley. We went through everything he said he had, so we'll find it.
You call the jail, you'll have help him.
Back to 3, Warren.
Berlanga. I'm ready on Posada. I just need to pull up the indictment. Let's go on the record, please. This is cause number 2021 CR 1433, the state of Texas versus Romaldo Posada. Attorneys, please make your announcements for the record. Amir, this is yours.
Yes, Judge. Judge Amir Memori for Mr. Posada.
Gretchen, this is yours.
I'm sorry, I didn't know I was muted. Gretchen Flater for the state.
Mr. Posada is appearing by video conference. Go ahead and tell me your full name, sir.
Romualdo Posada.
On the screen, I have the true bill of indictment that was filed in this case. I'm going to go over the counts, but State, can you tell me which count we're going to proceed on?
Count 2, paragraph A and B.
Count 2, the intoxication assault. It only has, count 2 only has one paragraph.
Okay, then count 2.
Okay, so just on the intoxication assault.
Yes.
All right, so count 2 of the indictment is intoxication assault, Mr. Posada, and it is punishable by confinement in the Texas Department of Criminal Justice, the institutional division, for any period between 2 and 10 years confinement. It also carries a possible fine of up to $10,000. Mr. Posada, while we're doing your plea, it's going to be very important that you stay on camera and that I can see you at all times, because if not, I'm just going to move on to the next plea. So find a place to sit, unmute yourself, and stay on camera while I'm doing the plea.
There you go. Thank you, Judge. There he is.
Do you understand the range of punishment, Mr. Posada, that applies to intoxication assault?
Yes, ma'am.
You have the right to a jury trial on this charge. You also have the right to confront all the witnesses against you, and you have the right to remain silent. Those are your constitutional rights. Do you understand those?
Yes, ma'am.
When you sign this document that I have on the screen called the waiver of rights, what you're telling me is that you're going to give up your constitutional rights. Is that what you intend to do?
Yes.
Is this your electronic signature here above the words Romualdo Posada?
Correct.
Yes?
Yes.
Are you a citizen of the United States?
Yes.
If you were not a citizen of the United States, I'm still required to tell you that a plea of guilty or no contest to this charge could result in deportation, exclusion from admission to the country, or denial of naturalization under federal law. Mr. Posada, are you satisfied with the representation of your attorney?
Yes.
Mr. Memori, does your client have a rational and factual understanding of the proceedings against him?
He does, Your Honor.
Has he been able to assist you in the preparation of any defenses?
He has, Your Honor.
In your opinion, is he mentally competent to waive his rights and enter into a plea?
Yes, Your Honor.
I will accept the waiver of rights and make it part of the record. Mr. Posada, on the screen, I have the plea bargain agreement in this case. It calls for an application. It's an opposed application for probation and the cap of 8. So you will have to come back for sentencing in person. We're going to order some evaluations at the sentencing hearing. You're basically leaving it up to me whether you get probation or not. If I grant probation, it could be up to 10 years. If I don't grant probation, your punishment cannot exceed 8 years confinement. Is that your understanding of the agreement?
Yes.
Mr. Memori, is that your understanding of the agreement?
It is, Your Honor. Yes.
And Ms. Flater, is that your understanding?
Yes, Judge.
What is your plea to the charge of intoxication assault? Is it guilty, not guilty, or no contest?
No contest.
Are you entering a plea of no contest because you have talked about this matter with your attorney and you believe it's in your best interest to do so?
Yes, ma'am, I have.
And are you doing this freely and voluntarily?
Yes.
Has anyone forced you to enter a plea
No.
or offered you anything in exchange for a plea?
No.
I will accept the plea of no contest. I find the plea is voluntarily made. And And I will ask the state to tender its proof.
It offers States Exhibit 1 and its attachments.
No objections, Your Honor.
States 1 is admitted. Mr. Mamori, are you satisfied the state complied with Article 3914 in this case?
Yes, Your Honor.
I will sign the discovery acknowledgement and make it part of the record. Ashley, what is the sentencing date that you're looking at?
6 weeks, judge puts it out at 3/24.
Pens are working. State, I think in the steps, you put the other charge, not the intoxication assault.
Okay.
Can we, can you just send the page, that page by itself, and we'll strike through this when I print it out?
I don't know how to do that.
So does this page, just
Yeah.
reproduce this page?
Okay.
And we could do it before sentencing. It doesn't have to be today. We all understand we're going on the intoxication assault. Let's go back on the record. I do find the evidence is sufficient to substantiate your guilt. I will make no other findings. We're going to reset this matter for sentencing on March 24th. That's in person, Mr. Posada, so you have to appear in my courtroom on that day. In the meantime, what you're going to do is you're going to go into a breakout room with probation, and they're going to give you instructions on how to complete both the TAP and the PSI. Okay, we're off the record on that case. We'll see you in March.
Judge, may I be excused?
Yes, sir. Thank you. So, Mr. Posada, you're going to see my probation officer is going to give you an invite to join her breakout room.
Thank you, Ashley. Thank you, Gretchen. Bye-bye.
What's the answer on Rachel Ortiz?
They got a hold of Mr. Winter, Judge. We can bring it back at 1:30.
Judge, Mr. Berlanga signed that other document.
Yes, sir. Let me pull it up. Okay, let's go on the record on Berlanga.
Thank you.
Ready, David? Let's go on the record. This is cause number 2022 CR 0092 and 2021 CR 10123, the state of Texas versus Timothy Berlanga. Attorneys, please make your announcements for the record.
Gretchen Plater for the state.
Warren Wolf for Mr. Berlanga.
Mr. Berlanga is appearing by video conference. Go ahead and tell me your full name, sir.
Timothy Berlanga.
I'm going to show you the indictments in both of your cases on the screen. The first indictment is for cause number 2021 CR 10123. That's the possession of a controlled substance in penalty group 1 less than a gram. That's a state jail felony. Do you understand that charge?
Yes, Your Honor.
And then you also have 2022 0092. That's the indictment for evading arrest or detention in a motor vehicle. Do you understand that charge?
Yes, Your Honor.
Okay, let's go over the range of punishment for the evading arrest. That's a third-degree felony, and it is punishable by confinement in the Texas Department of Criminal Justice, the Institutional Division, for any period between 2 and 10 years confinement. It also carries a possible fine of up to $10,000. Do you understand the range of punishment in that case, Mr. Berlanga?
Yes, Your Honor.
The state jail felony is punishable by confinement in the Texas Department of Criminal Justice, but that's confinement in the state jail facility for any period between 6 months and 2 years confinement. Do you understand that range of punishment?
Yes, Your Honor.
And just to be clear, that also has a possible fine of up to $10,000. Mr. Berlanga, on both of these matters, you have the right to a jury trial. You have the right to cross-examine the witnesses against you, and you have the right to remain silent. All of those are your constitutional rights that apply to both of these cases. Do you understand those rights?
Yes, Your Honor.
When you sign the waiver of rights, the document I have on the screen, in both of these cases, what you're telling me is that you want to give up those rights. Is that what you intend to do?
That is correct.
Are you a citizen? I'm sorry. Is this your electronic signature here at the bottom?
Yes, Your Honor.
And this is for cause number 0092. I also have cause number 10123. On the screen now, is this your electronic signature above the words Timothy Berlanga, defendant?
Yes, Your Honor.
And in both of these matters, is it your intention to give up your constitutional rights?
Yes.
Are you a citizen of the United States?
Yes, I am.
If you are not a citizen, I'm still required to tell you that a plea of guilty or no contest to this charge could result in deportation, exclusion from admission to the country, or denial of naturalization under federal law. Mr. Berlanga, are you satisfied with the representation of your attorney?
Yes, Your Honor.
Mr. Wolf, does your client have a rational and factual understanding of the proceedings in both of these cases?
He does.
Has he been able to assist you in the preparation of any defenses?
Yes.
In your opinion, is he mentally competent to waive his rights and enter into a plea?
Yes.
I will accept the waiver of rights in both of these cases and make it part of the record. Mr. Berlanga, on the screen, I have the plea bargain agreement for the cause number ending in 10123. The agreement calls for 180 days confinement in the Bexar County Jail pursuant to 1244. No fine, no application. It will run concurrent with the evading arrest. Is that your understanding of the agreement in that case?
Yes, Your Honor.
In the evading case, I have the plea bargain page on the screen. The evading arrest calls for confinement in the Texas Department of Criminal Justice, the Institutional Division, for 2 years. No applications, concurrent with, I think it means the possession case. And the state is going to dismiss 0091. Is that your understanding of the agreement in that case?
Yes, Your Honor.
The Comal County cases, are those felonies or misdemeanors?
They're felonies.
Okay, I will run it also additionally concurrent with those 2 matters. Is that
Okay.
your understanding of the agreement in this case?
Yes,
The
Your Honor.
evading? Okay.
Yes, Your Honor.
So let's start with the evading. What is your plea to the charge in the indictment? Is it guilty, not guilty, or no contest?
Guilty.
And on the possession less than a gram, what is
Guilty.
your,
Guilty, Your Honor. Yes,
in
ma'am.
both of these matters, are you entering a plea of guilty because you are guilty and for no other reason?
That is correct. Yes, ma'am.
Has anyone forced you to enter a plea on this case or any
No,
of these
ma'am.
cases?
No, Your Honor.
Has anyone offered you anything in exchange for your plea in both of these matters?
No, Your Honor.
I will accept your plea of guilty in both of these cases. I find the pleas are voluntarily made and I will ask the state to tender its proof.
State offers States Exhibit 1 and its attachment.
No objection.
States 1 is admitted. Mr. Wolf, are you satisfied the state complied with Article 3914 in this case?
Yes.
Well, in both of them.
Yes, Judge.
I will sign the discovery acknowledgement in both matters and make it part of the record. While I'm reading the steps, I'll also sign the dismissal. So give me just a minute. Clerks, how many days in does Mr. Berlanga have?
On the possession, judge, he has 90. On the evading, he has 101.
Let's go back on the record, please. We're going to start with the state jail felony, possession less than a gram. Mr. Berlanga, I do find the evidence is sufficient to substantiate your guilt, and I will find you guilty of the offense of possession of a controlled substance, penalty group 1, less than a gram. I will sentence you pursuant to your agreement to 180 days confinement in the Bexar County Jail pursuant to 1244 of the Penal Code. You do get credit for the time you have been in custody on this case. This will run concurrent with 2022 CR 0092. I do find the judgment is satisfied. This is a plea bargain case. I did follow the plea bargain agreement. You do not have a right to appeal this matter. Mr. Berlanga, do you understand?
Yes, Your Honor.
Let's move on to the evading arrest. In cause number 2022 CR 0092, I do find that the evidence is sufficient to substantiate your guilt, and I will find you guilty of the offense of evading arrest or detention in a motor vehicle. I will sentence you pursuant to your agreement to 2 years confinement in the Texas Department of Criminal Justice, the Institutional Division. You do get credit for the time you have been in custody on this case. This will run concurrent with cause number 2021 CR 10123. This will also run concurrent with Comal County case number CR 2019-138 and CR 2019-690. And both of those are out of Comal County. I have already signed the dismissal in 2022 CR 0091. Mr. Berlanga, this case is also a plea bargain case. I followed your plea bargain agreement, so you do not have a right to appeal. Do you understand?
Yes, Your Honor.
Okay, thank you. You're excused.
Thank you, Your Honor.
Thank you,
You're
Judge.
welcome. Yes, sir, Mr. Wilson, take care.
Judge, I just looked over the Rolando Posada. I think it is right. So it's the way that he commits intoxication and assault.
Okay.
Okay, I hadn't read it that carefully.
Okay, I think it's okay.
On Rachel Ortiz, we're just going to bring her back at 1:30. Ms. Ortiz, your attorney didn't log back on, so we'll see you at 1:30. And then after Rachel Ortiz, Henry Rodriguez.
I'm excused.
Yes, but they're going to hold on to you until 1:30. We'll see you back here at 1:30.
Okay, thank you.
Yes. Where is Henry Rodriguez? Okay, just unmute yourself. You're going to see a little light say unmute. Do you see it? It says host is asking to unmute yourself.
Okay.
All right, Mr. Rodriguez, let's go on the record. This is cause number 2020 CR 9255, the state of Texas versus Henry Rodriguez. Attorneys, please make your announcements for the record.
Samuel Laws for the state, Your Honor.
Bo Wood for the defendant, Mr. Rodriguez. He's present. We are ready.
Mr. Rodriguez is appearing by video conference from the Bexar County Jail. Go ahead and tell me your full name, sir.
Henry Rodriguez.
Okay, on the screen, I have the true bill of indictment that was filed in your case, Mr. Rodriguez. It alleges the offense of violation of bond or protective order by committing another assault. Do you understand the charge against you?
Yes.
Are we proceeding as charged, state?
Yes, Your Honor.
That is a third-degree felony, Mr. Rodriguez. It is punishable by confinement in the Texas Department of Criminal Justice, the Institutional Division, for any period between 2 and 10 years confinement. It also carries a possible fine of up to $10,000. Do you understand the range of punishment that applies?
Yes, ma'am.
On the screen, I have the court admonishments for you to look at with me. This is what tells you the range of punishment and the agreement and other rights that you have. You do have the right to a jury trial. You have the right to cross-examine the witnesses against you, and you have the right to remain silent. All of those are your constitutional rights, Mr. Rodriguez. You understand those?
Yes, Your Honor.
When you sign the documents, what you're telling me is that you want to give up those rights. Is that what you intend to do?
Yes, Your Honor.
Are you a citizen of the United States?
Yes, Your Honor.
If you were not a citizen, I'm still required to tell you that a plea of guilty or no contest to this charge could result in deportation, exclusion from admission to the country, or denial of naturalization under federal law. Mr. Rodriguez, I forgot to ask you, is this your electronic signature above the words Henry Rodriguez, defendant?
Yes, Your Honor.
Are you satisfied with the representation of your attorney?
Yes, Your Honor.
Mr. Wood, does your client have a rational and factual understanding of the proceedings against him?
Yes, ma'am.
Has he been able to assist you in the preparation of any defenses?
Yes, Judge.
In your opinion, is he mentally competent to waive his rights and enter into a plea?
Yes, Your Honor.
I will accept the waiver of rights and make it part of the record. Mr. Rodriguez, the plea bargain in this case is recommending deferred adjudication for a period of 4 years. There's a $1,000 fine. You're to complete the batterer's intervention prevention program. There is going to be an affirmative finding of family violence in this case. And there's a no contact order with Naomi Garcia. We're also going to conduct a DDRF evaluation and a TAP evaluation. And we're going to order 150 hours community service. Is that your understanding of the agreement in this case?
Yes.
Mr. Wood, is that your understanding?
It is, Judge. There are a couple of items I'd like to address with the court, but that in essence is our agreement.
Mr. Lyles,
Yes, Your Honor.
what is your plea to the charge of violation of bond or protective order by committing another assault? Is it guilty, not guilty, or no contest?
No contest.
Are you entering a plea of no contest because you have talked about this matter with your attorney and you believe it's in your best interest to do so?
Yes.
Are you doing this freely and voluntarily?
Yes.
Has anyone forced you to enter a plea
No, Your Honor.
or offered you anything in exchange for your plea?
No.
I will accept your plea of no contest. I find the plea is voluntarily made and I will ask the state to tender its proof.
State offer State's Exhibit 1 along with attachments.
We have had an opportunity to view it and have no objections.
State's one is admitted. Mr. Wood, are you satisfied the state complied with Article 3914 in this case?
Yes, Your Honor.
I will sign the discovery acknowledgement and make it part of the record. All right, let's go back on the record, please. Thank you. I do find the evidence is sufficient to substantiate your guilt. I will make no other findings at this time. I will grant the application for deferred adjudication for a period of 4 years, $1,000 fine, batterers intervention prevention program, affirmative finding of family violence, no contact order with Naomi Garcia. We're going to do the DDRF and TAP evaluation and 150 hours community service. Mr. Rodriguez, this is a plea. Oh, I'm sorry,
Yeah,
Mr. Wood, I
yeah,
apologize. You wanted to address some things. Go ahead.
I did, Judge, just that this young man is 39 years of age. He has 4 minor children. The 3 of those minor children are with Naomi Garcia, the complainant or the victim in this case. He went to Lanier, grew up in San Antonio, went to Lanier High School. I think he got his high school equivalency in the Navy, but he attended Austin College for several semesters, working on a business degree. He has a house he's purchasing. He has a job to go back to. Currently, he was just making deliveries for a pharmacy, delivering medications for a pharmacy. What we'd ask the court to consider possibly probating some of that fine. Maybe make the no contact order no harmful or injurious contact. I've told him that no contact means if you're pushing a grocery cart in the HEB and you see her, you abandon the cart and go walk outside, get your car and drive off. No harmful contact means you can go see your kids, but if she gets mad about anything, you got to leave. And so he's willing to do that if the court would consider that. The other would be, he had a county court 13 case, but I think Sam told me he's already filed a dismissal on that. And I'd ask for a minimum supervisory fee, Judge, just because he has 4 minor children.
I am signing the dismissal now. I
thank you,
will, yeah, that's done. But with regards to the no contact order, it seems to me like the protective order that was issued has already expired. State, has she renewed it, or what is her position on the contact?
Judge, I believe she does not want contact. She has not renewed the protective order from what I can see.
And she wants a no contact?
Yes, Your Honor.
Okay, we're gonna keep it no contact order.
Yes, sir.
If he has a custody order that allows him to see his children and I need to modify the terms of the contact, I can, and I can do that through the probation department. And I will probate $500 of the fee, the fine. And I will order a $50 supervisory fee.
Thank you, Judge.
This is a plea bargain case, Mr. Rodriguez. I did follow your plea bargain agreement. You do not have a right to appeal. Do you understand?
Yes, Your Honor.
You're going to go in a breakout room with probation so they can give you instructions on how to report. And you should not have any other holes from what I could tell.
And yeah, if I might go in the breakout room with him, Judge, just to go over that.
Sure.
Thank you, Judge.
No problem. Thank you.
Thank you.
Veronica, on your case, you're going to need an interpreter, correct?
Yes, Judge.
Can you guys, do you want to come back a little later? I have one plea in front, at least one plea in front of you.
We can, but I have another court at 2:00, so.
If you don't mind, I can do yours right after Juan Pastrano.
That's fine, Judge. I had messaged Ashley when we turned in the paperwork that we were going to need the interpreter, so I'm sure she.
Yeah, the interpreter is on.
Okay.
So the interpreter is on. I don't want to lose them. And then,
She logged in, but then they logged out. They wanted to know whenever you're ready to call them.
okay, well, I'm ready. I'm going to do Pastrano next and then them. Richard, I'll get to yours after the interpreter, if that's okay.
No worries. I'm busy doing other stuff.
Oh, I know. And you can have lunch. You can. the good thing about Zoom, right? That we could
That's right.
multitask. On Pastrano, he's gonna go on the retaliation.
Retaliation and a drug case, Your Honor. Plead concurrent. And there is another drug case that I will TIC at the appropriate time.
I have all the documents, just making sure. So you're gonna dismiss 1479.
I don't have the immediate, yes, Judge. I don't have the immediate case in front of me, but it's the one that he picked up after the fact. Yes. Okay.
Yep. Yes. Which Saturday? Okay, let's go on the record. This is cause number 2021 CR 100, not 100. 2021 CR 10554 and 10555, the state of Texas versus Juan Pastrano. Attorneys, please make your announcements for the record.
Travis Rodriguez for the state of Texas.
Jackson Lindsay on behalf of Juan Pastrano. Judge, we're ready to proceed.
Where's the other Jackson Lindsay that had long hair?
That is long gone.
No way.
Truth be told, Judge, the real reason I cut it off is because I had a jury trial over in Del Rio, and I needed to be dressed appropriately to represent my client. And so I felt I needed to be in federal court. Yeah.
Oh, you couldn't even pull it back or anything.
Well, I owed it to my client. I said, look, I better dress as conservative as I can. So, but that's gone. It was 14 months of growth. It's I can always go back, but for now I'm short-haired again.
All right, Mr. Pastrano is appearing by video conference from the Bexar County Jail. Mr. Pastrano, can you tell me your full name?
Juan Pastrano.
Yes. Juan Pastrano, right?
Yes, ma'am.
On the screen, I'm showing you the true bill of indictment that was filed in each of your cases. The first one is the retaliation and cause number ending in 554. Do you understand the charge in that case?
Yes, ma'am.
And then you also have the possession, 1 to 4 grams, possession of a controlled substance, penalty group 1, 1 to 4 grams. Do you understand that charge?
Yes, ma'am.
Okay. We're going to start with the drug charge. That is a 3rd-degree felony. In fact, both of your cases, I'm showing you the retaliation now, and then this is the possession of a controlled substance, 1 to 4 grams. Both of those cases, Mr. Pastrano, are 3rd-degree felonies. A 3rd-degree felony is punishable by confinement in the Texas Department of Criminal Justice, the institutional division, for any period between 2 and 10 years confinement. It also carries a possible fine of up to $10,000. Do you understand the range of punishment that applies?
Yes.
You have the right to a jury trial on both of these cases. You also have the right to confront the witnesses or cross-examine the witnesses against you, and you have the right to remain silent. Those are your constitutional rights. Do you understand those?
Yes, ma'am.
When you sign this document, what you're telling me is that you want to give up those rights in each of those cases. Is that what you intend to do, Mr. Pastrano?
Yes, it is.
Is this your electronic signature here at the bottom above the words Juan Pastrano?
Yes, it is, ma'am.
And that is for the possession case. Let me show you the admonishments for the retaliation case. Is this your electronic signature here?
Yes, Your Honor.
Are you a citizen of the United States?
Yes, I am.
If you are not a citizen, I'm still required to tell you that a plea of guilty or no contest to this charge could result in deportation, exclusion from admission to the country, or denial of naturalization under federal law. Mr. Pastrano, are you satisfied with the representation of Mr. Lindsay?
Yes, I am.
Mr. Lindsay, does your client have a rational and factual understanding of the proceedings against him?
He does.
Has he been able to assist you in the preparation of any defenses?
Yes, he has.
In your opinion, is he mentally competent to waive his rights and enter into a plea?
Yes, I believe he's competent.
I will accept the waiver in both of these cases and make it part of the record. Mr. Pastrano, on the screen, I have the plea agreement for the retaliation case. The agreement calls for 2 years confinement in the Texas Department of Criminal Justice, the institutional division. There are no applications. It will run concurrent with the possession case. Is that your understanding of the agreement in this case?
Yes, it is.
In the possession 1 to 4 grams, the agreement looks identical. 2 years confinement in the Texas Department of Criminal Justice, the institutional division. It'll run concurrent with the retaliation case. It also appears to me that the state's going to dismiss the other charge, correct, state?
Honor, I was overzealous in completing the paperwork, but on the record, I am going to state that the other outstanding case, 2021 CR 11479, will be dismissed upon his plea in this case.
Mr. Pastrana, is that your understanding of the agreement in the possession case?
Yes.
What is your plea to this charge? Is it guilty, not guilty, or no contest?
No contest.
And what is your plea to the retaliation? Is it guilty, not guilty, or no contest?
No contest.
In both of these matters, are you entering a plea of no contest because you have talked about this matter with your attorney and you believe it's in your best interest to do so?
Yes.
And are you doing this freely and voluntarily?
Freely.
Anyone force you to enter a plea today
No, ma'am.
or offer you anything in exchange for your plea?
No, ma'am.
I will accept your plea of no contest. I find the plea is voluntarily made in both matters, and I will ask the state to tender its proof.
Part of the plea paperwork, I have attached some stipulated evidence. There was also a file that was too large to include in the preferred Adobe sign format. I forwarded that to the court by way of email. I attached opposing counsel to that email. So at this time, state offers and evidence states exhibit 1 and all of its attachments in both matters before the court, pending any objections.
No objection.
States 1 is admitted in both cases. Mr. Lindsay, are you satisfied the state complied with Article 3914?
Yes.
I will sign the discovery acknowledgement in both of those matters and make it part of the record.
Your Honor.
Yes.
How much back time do I got?
Jessica, how much time are we talking about?
On his possession, it's 151. On the retaliation, 161.
Okay. Wait just a minute, please.
Hear you, Your Honor.
I was on mute the whole time. It's fine. It's fine. Mr. Pastrano, can you hear me?
Yes, ma'am. No, I can.
Okay. All right. Sorry. I
That's
apparently
okay.
missed it.
Ma'am, I
On
had a question. I had a question. Is 151 and 161 add them together?
No, it's in each case.
Do I add them together like, so it's what, do 310 days?
So no, you only have 151 on one case and 161 on another one.
So how much is
You
that?
don't
So
add
what,
those up.
so what is that, 161 days in?
So yes, you have almost 6 months, not quite.
Okay. All right,
All
just making sure. Thank you.
Hold on, I'm not finished. In cause
Yes,
number
ma'am.
2021 CR 10555, I do find the evidence is sufficient to substantiate your guilt, and I will find you guilty of the offense of possession of a controlled substance, penalty group 1, 1 to 4 grams. David, are you with me?
Yeah, you just started before I was ready.
Sorry, I didn't look up, David. I'm sorry. I'll start over. In 2021 CR 10555, I do find the evidence is sufficient to substantiate your guilt, and I will find you guilty of the offense of possession of a controlled substance, penalty group 1, 1 to 4 grams. I will sentence you pursuant to your agreement to 2 years confinement in the Texas Department of Criminal Justice, the Institutional Division. You do get credit for the time that you have been in custody on this case. This will run concurrent with 2021 CR 10554. This is a plea bargain case. I did follow your plea bargain agreement, Mr. Pastrano. You do not have a right to appeal. Let's move on to cause number 2021 CR 10554. I do find the evidence is sufficient to substantiate your guilt, and I will find you guilty of the offense of retaliation. And I will sentence you pursuant to your agreement to 2 years confinement in the Texas Department of Criminal Justice, the Institutional Division. This will run concurrent with 2021 CR 10555. This case is also a plea bargain case, Mr. Pastrano. I did follow your plea bargain agreement. You do not have a right to appeal. Do you understand?
Yes, ma'am.
Okay, thank you, sir. You're excused. And there's a dismissal coming for the third case. I'll sign that as well.
All right, thank you.
Thank you, sir.
Judge Veronica's computer broke down. She said she's gonna log in later.
Who?
On Albaran Barrientos, Veronica.
Oh, okay. All right. Norma, if you want, we'll call you when we're ready because we're not going to be ready.
I talked to Norma, Judge. She logged off.
Okay. Next one would be Garza then. Albaran Barrientos can come back at 1:30. Mr. Brown, do you want to come back a little after 1:30 and we'll do Flores?
Yes, that's fine, Your Honor.
Thank you.
Thank you.
Flores, Sylvia can come back. Ready, Dave? We'll take a break after this. On the record, this is cause number 2020 CR 11355, the state of Texas versus Raymond Garza. Attorneys, please make your announcements for the record.
Yes, Your Honor. Luis Echevarria for the state of Texas.
And Your Honor, this is Richard Garcia for the defendant Raymond Garza. We're ready.
Mr. Garza is appearing by video conference from the Bexar County Jail. Go ahead and tell me your full name, sir. You have to unmute yourself, okay? You see the screen is telling you the host is asking to, and there you go. You got it. Mr. Garza, on the screen, I have the true bill of indictment that was filed in this case. It alleges the offense of retaliation. Do you understand the charge that you have today?
Yes, ma'am.
And Your Honor, the state does have a motion.
Go ahead.
The state moves to proceed on the lesser included offense of an attempted retaliation in this case, Judge. That would
No
make it a
objections,
state jail
Your Honor.
felony.
I'm sorry, no objections, Your Honor.
A state jail felony, Mr. Garza, is punishable by confinement in the Texas Department of Criminal Justice, and that's for confinement in a state jail facility. It also carries a possible fine, for any period of confinement from 6 months to 2 years confinement. It also carries a possible fine of up to $10,000. Do you understand the range of punishment that applies?
Yes, Your Honor.
You have the right to a jury trial. You have the right to confront or cross-examine the witnesses against you. You also have the right to remain silent. Those are your constitutional rights. Do you understand those?
Yes, Your Honor.
When you signed this document called the court admonishments, what you're telling me is you want to give up those rights. Is that what you intend to do?
Yes, Your Honor.
Is this your electronic signature above the words Raymond Jesse Garza, defendant?
Yes, Your Honor.
Are you a citizen of the United States?
Yes, Your Honor.
If you were not a citizen, I'm still required to tell you that a plea of guilty or no contest to this charge could result in deportation, exclusion from admission to the country, or denial of naturalization under federal law. Mr. Garza, are you satisfied with the representation of Mr. Garcia?
Yes, Your Honor.
Mr. Garcia, does your client have a rational and factual understanding of the proceedings against him?
I believe he does, Judge.
Has he been able to assist you in the preparation of any defenses?
Yes, he has, Your Honor.
And in your opinion, is he mentally competent to waive his rights and enter into a plea?
Yes, Your Honor.
I will accept the waiver of rights and make it part of the record. Luis, are you going to send me a dismissal?
I already have, Your Honor. Let's see. For Mr. Garza, it went out around 11:30, 11:34 this morning. I can send it. I can send you a.
It is. I found it.
Okay.
Mr. Garza, on the screen, I'm showing you the plea bargain agreement. It calls for 240 days confinement in the Bexar County Jail pursuant to 1244A. There is no applications in this case, and the state is going to dismiss the resisting arrest, 646-217. Is that your understanding of the agreement in this case?
Yes, Your Honor.
Yes?
Yes, ma'am.
Mr. Garcia, is that your understanding?
Yes, it is, Your Honor.
And state, Mr. Echevarria, is that your understanding?
It is, Your Honor.
What is your plea to the charge of attempted retaliation? That's a state jail felony. Is it guilty, not guilty, or no contest?
No contest.
Are you entering a plea of no contest because you have talked about this matter with your attorney and you believe it's in your best interest to do so.
Yes, Your Honor.
And are you doing this freely and voluntarily?
Yes, Your Honor.
Has anyone forced you to enter a plea?
No, Your Honor.
Has anyone offered you anything in exchange for your plea today?
No, Your Honor.
I will accept your plea of no contest. I find the plea is voluntarily made, and I will ask the state to tender its proof.
The state offers State's Exhibit 1 and all attachments pending any objection from Mr. Garcia.
No objections, Your Honor.
State's one is admitted. Mr. Garcia, are you satisfied the state complied with Article I apologize, 3914?
Yes, Your Honor, I am.
I will sign the discovery acknowledgement and make it part of the record. Give me just a minute, please. And I already signed the dismissal.
Thank you, Judge.
Mhm.
Do I have any back time?
Yes, clerks, how much time does he have in?
55 days, Judge.
55?
Yes.
That was on this case, but he also has, there's like another,
The
he has-
misdemeanor?
On the misdemeanors, what the clerks had talked about, and Mr. Garcia is right, there's 55 days, Judge, on this felony case. And then I think the misdemeanor, he has, I think 107?
107.
Okay.
It'll come up. Ah, no. Sorry, guys. I deleted something.
Sorry, let's go back on the record, please. I do find the evidence is sufficient to substantiate your guilt. Mr. Garza, I do find you guilty of the state jail felony attempted retaliation. And I will sentence you to 100 days confinement in the Bexar County Jail. You do get credit for the time that you have been in custody on this case. And I do find the judgment is satisfied. This is a plea bargain case, Mr. Garza. I did follow the plea bargain agreement, so you do not have a right to appeal. Do you understand?
Yes, yes, Your Honor.
If you have no other holds, you should be released.
Thank you so much, Judge.
And no more being extremely intoxicated, yelling at the officer. I mean, you know that, right? You know that
Yes.
that's what allowed you here. You
I'm
gotta
done
not do that.
I'm done drinking.
Right.
I have cirrhosis of the liver.
Okay, thank you for your excuse. Thank you, Richard. Thank you for your
Thank you,
patience.
Judge. Continue.
You too.
Hey,
All right, guys,
So I don't have no more days to do here, or I still have a few days to do?
you're done.
Okay,
You're done.
thank
Be
you.
out this afternoon.
Okay, thank you, sir. Thank you,
Thank
Your Honor.
you.
God bless
You're
you.
welcome.